round 2, day 1. I think that's what we did. So we're going to go and do it. We're going to do it the only way we know how. Which is right here, right now. Let's go.
Thank you all.
The hearing will come to order.
Let me know if the music is too loud. It helps because of the static. You know, the mics in the 90s weren't as good as they are today.
Good morning, Judge. Welcome to the blinding lights. It's a pleasure to have you here. And let me begin also by indicating that the morning's going to be painless, Judge, or maybe the most painful part of the whole process, because you're going to hear from all of the committee who have an opening statement, and then a half a dozen senators who are going to introduce you. And so you'll hear from about 20 senators before you get to speak. It could be the most painful part of the process. But let me begin today, Judge, on a slightly more serious note. This committee begins its 6th set of Supreme Court confirmation hearings held in the last 5 years, a rate of change that is unequaled in recent times. If you're confirmed, Judge Thomas, you will come to the Supreme Court in the midst of this vast change. In 4 years, Justices Powell, Brennan, and Marshall will have been replaced by Justices Kennedy, Souter, and Thomas. Because of these changes, many of the most basic principles of constitutional interpretation of the meaning that the Supreme Court applies to the words of the Constitution are being debated in this country in a way they haven't for a long time, in a manner unlike anything seen since the New Deal. In this time of change, fundamental constitutional rights, which have been protected by the Supreme Court for decades, are being called into question. In this time of change, the Supreme Court's self-restraint from interference in fundamental social decisions about the regulation of health care, the environment, and the economy are also being called into question. Judge Thomas, you come before this committee in this time of change with a philosophy different from that which we have seen in any Supreme Court nominee in the 19 years since I have been in the Senate. For as has been widely discussed and debated in the press, you are an adherent to the view that natural law philosophy should inform the Constitution. Finding out what you mean when you say that you would apply the natural law philosophy to the Constitution is, in my view, the single most important task of this committee, and in my view, your most significant obligation to this committee. This is particularly true because of the period of vast change in which your nomination comes before us. Judge, to explain why this is such an important question, at least to me, we need only look at the 3 types of natural law thinking which have, in fact, been adopted by the Supreme Court of the United States in the past, and which are being discussed and debated by constitutional scholars today. The first of these views sees natural law as a moral code, a set of rules saying what is right and what is wrong, a set of rules and a moral code which the Supreme Court should impose upon the country. In this view, personal freedom to make moral choices about how we live our own lives should be replaced by a morality imposed on the conduct of our private and family lives by the court. The Supreme Court, as you know, Judge, actually took such an approach in the past, holding in 1873, for example, that women could not become lawyers because it was not, in the court's phrase, in their nature. Now, no one wants to go back to 1873. No one wants to go back that far today. But there are natural law advocates who extol the 20th century version of this philosophy. For they believe that it's the job of the courts to judge the morality of all our activities, whether they occur, wherever they occur, paying no respect to the privacy of our homes and our bedrooms. They believe the court should forbid any activity contrary to their view of morality and their view of natural law. Those who subscribe to this moral code view of natural law call into question a wide range of personal and family rights, from reproductive freedom to each individual's choice over procreation, to the very private decision we now make about what is and what is not a family. They want to see the government make these choices for us by applying, to quote one report, their values and norms. Or, if the legislature doesn't do it, by judges applying their values and norms. Needless to say, Judge Thomas, this sort of natural law philosophy is one which I believe this nation cannot accept. But it's not the only radical natural law philosophy that is being debated as we sit here today, is being debated in the law schools and among the philosophers of this country. For there is another group that wants to reinvigorate another period of the Supreme Court's past, when the court used natural law to strike down a whole series of government actions aimed at making the nation a better place for Americans to live. Those natural law rulings struck down such laws as the child labor laws, minimum wage laws, and laws that required safe working conditions. They held that the natural law of freedom of contract and the natural law right to property created rights for businesses and corporations that rose above the efforts of government to prevent the ills they created. They put these so-called economic rights into a zone of protection so high that even reasonable laws aimed at curbing corporate excesses were struck down. Now again, no one is proposing to take us all the way back to this so-called Lochner era. But there are those who wish to employ the same reasoning that was used in that era. Today's natural law proponents of what they term new economic rights and new property rights have called into question many of the most important laws enacted in this century. Laws protecting the environment, our water and our air. Laws regulating child care and senior citizens facilities. And even called into question the constitutionality of the Social Security system. Now, Judge Thomas, you've made it abundantly clear that you do not subscribe to the most extreme of these views. But you have said that you find some of these views, to quote you, attractive, and that you support the idea, quote, of an activist Supreme Court that would strike down laws regulating economic rights, end of quote. And again, this is a version of natural law, a vision of natural law, that we have moved far beyond and that most Americans have no desire to return to. And there's a third type of natural law, Judge. It's the one that mirrors how the Supreme Court has understood our Constitution for the bulk of this century. And it's the one that I believe most Americans subscribe to. It is this view of natural law that I believe, I personally, to be upfront about it, think is appropriate. In this view of natural law, the Constitution should protect personal rights falling within the zone of privacy, speech, and religion the most zealously. Those rights that fall within that zone should be most zealously protected. These personal freedoms should not be restricted by a moral code imposed on us by the Supreme Court or by unjust laws passed in legislative bodies. Indeed, the Supreme Court has protected these freedoms by striking down laws that would prohibit married couples from using contraception, deny the right of people to marry whomever they wish, or laws that tell parents that they could not teach their children a second language or could not send them to a private school. They struck down those legislative initiatives in the past. But while recognizing that natural law and our Constitution protect these rights, the same court has also recognized that government must act to protect us from many of the dangers of modern life. That government should stop polluters from polluting, stop businesses from creating unsafe working conditions, and so on. Yes, these government actions do limit freedom. They do limit freedom. They limit the freedom to contract. They limit the freedom to use one's property exactly as they would wish. They limit the freedom to pollute. They limit freedom. Or, as we saw in North Carolina recently, they limit the freedom of a factory worker to lock his employees into a building where 25 of them perished in a fire. But this limitation on property, recognized as constitutional by the court, is a balanced liberty that we've come to expect our government to provide. This is the balance, in my view, that the framers of our Constitution enshrined in that great document. They wanted, to use their words, an energetic government. But they also wanted a government to protect fundamental personal freedoms. And today we've achieved that balance by having the Supreme Court extend great protection to personal freedoms while declining to block laws that reasonably regulate our economy, our society, our property. Now, adopting a natural law philosophy that upsets that balance, either by lessening the protection given those rights falling within the zone of personal and family privacy and speech and religion, or adopting a natural law philosophy that lessens the power of government to protect the environment, lessens the power of government to regulate corporate excesses, or lessens the power of government to create institutions like Social Security, would, in my view, be a serious mistake and a sharp departure from where we have been for the last 40 years. Judge Thomas, there are signs in your writing and speeches that you accept the present balance, but there are also signs that you would apply natural law to effect changes in the balance I've just referred to. Changes to replace our freedom to make personal and family choices without government imposing their moral code, and to thrust the court into economic and regulatory disputes that it now stays out of. Judge, if this committee is to endorse your confirmation to the Senate, we must know, in my view, we must know with certainty that neither of these radical constitutional departures is what you have in mind when you talk about natural law. So, Judge, over the course of these hearings, I'll be asking you about how your natural law philosophy applies to each of these areas, both to the areas of personal freedom and to the areas of economic issues. It will take some time to cover it, Judge, and some of it, as you know as well or better than I, is somewhat esoteric. But cover it we will, and we will cover it carefully. In closing, Judge Thomas, I want to return to where I started, the importance of your nomination. Some people say that the Supreme Court is already conservative, and they ask what difference it makes to have an additional conservative on the bench. Well, I think that's the wrong question. I reject that argument. First of all, I do not deny the President the right to appoint a conservative. Matter of fact, I would be dumbfounded if he didn't. And so I fully expect the Supreme Court to be a more conservative body after Justice Marshall's successor is confirmed than before Justice Marshall retired. But such an additional move to the right, which I expect, pales in comparison to the radical change in direction some are urging on the court under the banner of natural law. Pales in comparison to some of the changes that some of the people who are your strongest supporters have been urging on the philosophic thought and the notion of constitutional interpretation for the past decade. Thus, we're not seeking here to learn, at least I am not seeking here to learn, whether or not you're a conservative. I expect no less, and I believe you when you say you are. Instead, what we must find out is what sort of natural law philosophy you would employ as a justice of the Supreme Court. For that court is in transition, and if you're confirmed, you will play a large role in determining what direction it will take in the future. Judge, because of your youth, and God bless you for it, I never thought I'd be sitting here talking about the youth of a nominee to the Supreme Court. But I am. Heck, you are 6, 7 years younger than I'm 48. How old are you, Judge? 42, 3?
Well, I've aged over the last 10 weeks, but 43.
43 years old. Because of your youth, Judge, you'll be the first Supreme Court justice the Senate will ever have confirmed, if it does, that will most likely write more of his opinions in the 21st century than he will write in the 20th century. To acknowledge that fact alone, Judge, is to recognize the unique significance of your nomination and the care with which this committee must look at it. In closing, Judge Thomas, let me say that this committee's obligation is to be open and to be fair, and I hope you believe we have been that way thus far. We have many serious questions to ask you, Judge, and it will take time to get them all answered. And so any time you need a break, any time you just get tired sitting there, let us know, because we are testing the content of your mind, not your physical constitution, to be able to sit there for a long time. In welcoming you to these hearings, Judge, I welcome you also to a dialogue I believe that will have historic impact on the Supreme Court, the country, and historic impact for all Americans. We're pleased to have you join us here today, Judge, in what I consider to be a great endeavor and the most serious obligation this committee can undertake. Again, welcome, and I will now yield to my senior colleague from the state of South Carolina, the ranking member, Senator Thurmond.
Thank you, Mr. Chairman. Mr. Chairman, today the committee begins hearings to consider the nomination of Judge Clarence Thomas, being Associate Justice of the Supreme Court of the United States. This makes the 7th nominee to the Supreme Court that this committee has considered in the past 10 years, and once confirmed, will be the 106th person to serve as a justice. As well, I might say, it is the 24th Supreme Court nomination that I have had the opportunity to review during almost my 37 years in the Senate. As these hearings begin, we must remain keenly aware that we face a solemn responsibility. This committee undertakes no greater responsibility than the review of nominees to the federal judiciary. When a nominee is considered for the Supreme Court, our responsibility is an enhanced one. Those chosen for a seat on our nation's highest court occupy a position of great authority, trust, and power, as this appointment is one of life tenure without accountability by popular election. Members of the Supreme Court make vitally important decisions and can only be removed in very limited circumstances. A Supreme Court justice must be an individual who understands the responsibility to the people of this nation, the concept of justice, and the magnificence of our Constitution. Mr. Chairman, I've always believed that our Constitution is the most enduring document ever penned by the hand of man, certainly remains the finest, most significant political document ever conceived. It creates the basic institutions of our national government and spells out the powers of these institutions, the rights of our citizens, and the basic freedoms we all deeply cherish. At an early age, I developed a deep and abiding respect for this document, which stands as the centerpiece of mankind's struggle for self-determination. The fact that our Constitution has survived since its adoption in 1787 is a true testament to its remarkability. When a vacancy occurs on the Supreme Court, it is one of the few times that all three branches of government are so greatly impacted at the same time. The head of the executive branch, the President of the United States, elected by the people, chooses a nominee. This nominee will sit on the highest, most prestigious, and most powerful court within our judicial branch. The Senate, as part of the legislative branch, is called upon to review the nominee to ensure that he or she is qualified to serve on the most important court in America. I believe this process, which embraces all three branches of government, signifies the majesty of our system and underscores the brilliance of our founding fathers. Clearly, our magnificent Constitution confers tremendous responsibility on the Senate in a vast number of areas. In the confirmation process, the Senate alone holds exclusive authority to advise and consent on all judicial nominations. While the President of the United States has the constitutional authority to appoint judges of the Supreme Court, the advice and consent role of the Senate is one of the most important ones we undertake. The Senate has assigned the task of holding hearings and the detailed review of judicial nominees to the Judicial Committee. It is a task that this committee has undertaken with the clear awareness of the importance of our role in the confirmation process. The significance of this committee's role cannot be underestimated. In this century, no nominee to the Supreme Court has been confirmed by the full Senate after failing to attain a majority of the votes of members of this committee. Mr. Chairman, the role of the Supreme Court in our history has been vital because the court has been called upon to solve many difficult and controversial problems, using its collective intellectual capacity, precedent, and constitutional interpretation to solve them. Throughout the course of our nation's history, the court has been called on to administer justice. As George Washington said, and I quote, "The administration of justice is the firmest pillar of good government," end quote. There is every reason to expect that the court's role in the administration of justice will continue to be a major factor in the future. For this reason, an individual chosen to serve on the Supreme Court must be one who possesses outstanding qualities. The impact of the decision of the court requires that a nominee is eminently qualified to serve. During my consideration of the previous 23 nominees to the High Court, in my almost 37 years, I have often reflected on the attributes I believe a Supreme Court justice should possess. As we again consider a nominee to the Supreme Court, I believe these special qualities warrant reiterating. First, unquestioned integrity. A nominee must be honest, absolutely incorruptible, and completely fair. Second, courage. The courage to decide tough cases according to the law and the Constitution. Third, compassion. While a nominee must be firm in his decisions, he should show mercy when appropriate. Fourth, professional competence, the ability to master the complexity of the law. Fifth, proper judicial temperament, the self-discipline to base decisions on logic, not emotion, and to have respect for lawyers, litigants, and court personnel. And sixth, an understanding of the majesty of our system of government, the understanding that only Congress makes the law, that the Constitution is only changed by amendment, and that all powers not delegated to the federal government are reserved to the states. I believe an individual who possesses these qualities will not fail the cause of justice. As we begin these hearings, there's every indication that Judge Thomas possesses the necessary attributes to be an outstanding member of the Supreme Court. Mr. Chairman, upon reviewing the decision Judge Thomas wrote and in which he participated on the Court of Appeals, I have concluded that Judge Thomas has exhibited an adherence to the rule of law and the true principles upon which our nation was founded. Without question, the decisions he has written are within the mainstream of judicial thinking. He has articulated a clear and concise understanding of the law and conforms to established principles of constitutional interpretation. Some have stated that Judge Thomas has articulated a personal philosophy of law and constitutional interpretation, which would curtail individual rights. I strongly disagree with those who have reached that conclusion. In fact, Judge Thomas has stated that he believes, and I quote, that equality is the basis for aggressive enforcement of civil rights laws and equal opportunity laws designed to protect individual rights. Those are words stated by a person who truly believes in the civil rights of the individual and a commitment to the principles of fairness and equality, not a nominee who is out of the mainstream of judicial interpretation and analysis. An examination of the professional record of Judge Thomas provides no valid reason to believe he would seek to diminish the rights of any American citizen. Judge Thomas acknowledges that he has been a beneficiary of the diligent work of individuals such as Justice Thurgood Marshall and others involved in civil rights efforts. Mr. Chairman, the issue of judicial philosophy or ideology has often been raised in relation to recent nominees to the Supreme Court. Some argue that philosophy should not be considered at all in the nomination process, while others state that philosophy should be the sole criteria. It is not appropriate that philosophy alone, I repeat, alone, should bar a nominee from the Supreme Court, unless that nominee holds a belief that is contrary to the fundamental, long-standing principles of our nation. Clearly, if a philosophical litmus test can be applied to defeat a nominee, then the independence of the federal judiciary would be undermined. Judges are not politicians put in place to decide cases based on the views of a political constituency, but are sworn to apply constitutional and legal principles to arrive at decisions that do justice to the parties before them. The prerogative to choose a nominee to the Supreme Court belongs to the President, an individual elected by the people of this country. The full Senate has the opportunity to review that nominee, who comes to this body with a presumption, and I repeat, with a presumption in his favor. To reject a nominee based solely on ideology is inappropriate. Requiring a nominee to pass an ideological litmus test would seriously jeopardize the efficacy and independence of the federal judiciary. In closing, I believe Judge Thomas is well qualified to serve as a justice of our nation's highest court. He possesses the integrity, intellect, professional competence, and judicial temperament to make an outstanding justice. In addition to his personal struggle to overcome difficult circumstances early in his life is admirable. A review of his background shows he is a man of immense courage, who has prevailed over many obstacles to attain remarkable success. Mr. Chairman, the Supreme Court is the final arbiter of our nation's most important legal disputes. Its authority is immense. This immense authority places a great responsibility on each of us as we begin the thorough review of Judge Thomas to be an Associate Justice of that court. I look forward to a fair hearing with swift consideration of this nominee by the committee and the full Senate. Judge Thomas, we welcome you to the committee and look forward to your testimony. Thank you, Mr. Chairman.
Thank you very much, Senator. Senator Kennedy.
Thank you, Mr. Chairman. Good morning, Judge. Just to mention at the outset, we come to the nomination on the basis that the President makes the nomination, but it's a shared responsibility and an important responsibility for us to make a judgment on this, and might have some difference with my good friend and colleague from South Carolina, whether there is the presumption. I think any fair reading of the Constitutional Convention would show that this was to be a shared responsibility, and I think at least I and other members of the committee would look so. 200 years ago this year, the Bill of Rights became part of the Constitution. The Constitution itself confers upon the federal government the powers necessary to govern the country. But the Bill of Rights protects the fundamental rights that enable us to be truly free and to enjoy the full benefits of our democracy. Most important, the Constitution and the Bill of Rights preserve our individual liberty, and they are the nation's promise to the people that no American will ever be forced to stand before a column of tanks in any battle to keep our democracy. It is our guarantee that majority rule is limited and that each individual has certain basic rights that the government cannot invade. As we celebrate the bicentennial of the Bill of Rights, as we watch brave citizens in the Soviet Union and other lands struggle to attain similar rights and liberties, we feel justifiably proud of our system of government and the enduring achievements of the past 2 centuries. But we cannot permit our pride to diminish our commitment to preserving and strengthening our own democracy or dealing with the serious challenge that continue to confront us. The nomination which we begin considering today is an essential part of the process by which we safeguard the Constitution, the Bill of Rights, and our democracy itself. If confirmed, Judge Clarence Thomas will become one of 9 Supreme Court justices with the ultimate power to define the Constitution, interpret the Bill of Rights, and ensure that the limited powers of government stay limited. Many of us are concerned about the direction the Supreme Court has taken in recent years. It has increasingly abandoned its role as the guardian of the powerless in our society. It has repeatedly sought to turn back the clock on civil rights. It has relaxed the rules prohibiting the use of coerced confessions obtained by law enforcement officers. It has begun to retreat on the right to privacy. It has ruled that government officials can prohibit doctors and publicly funded clinics from practicing their profession to the best of their ability and giving their patients full medical advice. The Court has not hesitated to overrule earlier decisions with which the new majority disagrees. Justice Thurgood Marshall warned us in his final Supreme Court opinion that power, not reason, is the new currency of the Court's decision-making. Justice Marshall has been one of the greatest justices in the history of the Supreme Court. His courageous career is an inspiration to the nation, and his vision of the rule of law is an example to the world of the best in American justice. The person who replaces Thurgood Marshall on the Court will be deeply involved in fundamental decisions that will affect the rights of all Americans in the years ahead and may well determine the very nature of our democracy and the future of the Bill of Rights. For this reason, the Senate has a special responsibility to assess Judge Thomas's view of the Constitution and his dedication to individual rights and the separation of powers. We must decide whether he possesses a clear commitment to the fundamental values at the core of our democracy. In his life and in his career, Judge Thomas has overcome large barriers of poverty and injustice, and he deserves great credit for the eminence he has attained. In many ways, he exemplifies the promise of the Constitution and the American ideal of equal opportunity for all. But much more is at stake than Judge Thomas's background. Statements he has made and actions he has taken raise significant issues that must be addressed if he is to be confirmed by the Senate. For example, on the right to privacy, Judge Thomas has strongly commended an article entitled The Declaration of Independence and the Right to Life. One leads unmistakably from the other. That article refers to the constitutional right to abortion in Roe v. Wade as a conjured right, with not a single trace of lawful authority. According to the article, which Judge Thomas has called splendid, abortion is the constitutional equivalent of murder. If this view is accepted by the Supreme Court, not only Roe v. Wade will be overruled, neither Congress nor any state legislature will have the power to protect a woman's right to choose an abortion, even in cases of rape or incest. And federal and state governments will have an engraved invitation to invade other basic aspects of individuals' private lives. Judge Thomas's record also raises serious questions about his view on ongoing efforts to end discrimination in our society against women and minorities. The civil rights revolution of the past generation has been called the Second American Revolution. But it is a revolution that is far from complete. Millions of our fellow citizens are still left out and behind because of unacceptable conditions of discrimination based on race, sex, age, disability, and other forms of bigotry that continue to plague our society. As Congress and the administration struggle to deal with these urgent challenges, we will need a Supreme Court that is sensitive, not hostile, to our efforts. At the same time, Judge Thomas has stated that the Constitution protects economic rights as much as any other rights. Until the 1930s, a similar doctrine was used by the Supreme Court to strike down attempts by Congress and the states to protect the rights and very health and safety of workers against unfair abuses of power by unscrupulous employers and corporations. Few Americans today would want the Supreme Court to revive that discredited doctrine of constitutional protection for the rights of business at the expense of working men and women. Finally, Judge Thomas' role as chairman of the Equal Opportunity Commission has given him extensive experience in dealing with Congress. As a result of that experience, however, he has made some harsh statements about congressional oversight of executive agencies. Obviously, such oversight is an essential part of the constitutional system of checks and balances. It has served the nation well, and it must continue to do so. The Senate's constitutional role and confirmation of justices to the Supreme Court is one of our most important functions. I look forward to these hearings and to working with my colleagues on the committee and in the Senate to address these complex issues as thoroughly and as fairly as possible. The country deserves no less.
Thank you, Senator. Senator Hatch.
Thank you, Mr. Chairman. Before I begin my statement, let me say that I hope that Justice Marshall is well, and I wish him well. His career and service to our country throughout his life marks him, in my view, I think, as the single most influential lawyer in the 20th century, and maybe certainly one of the most influential lawyers of all time. Judge Thomas, welcome to the committee. This is your 5th confirmation before the United States Senate. I don't know many people who've had that experience or who've been able to endure that kind of an experience. I just want to say that I've known you for over 10 years, and I don't think President Bush could have made a better decision or a better judgment than to nominate you for the Supreme Court of the United States of America. This nominee is eminently qualified to be a Supreme Court justice. Judge Thomas has an excellent educational and legal background. He has served in all 3 branches of the federal government. And in so serving, as I've mentioned, he's already won Senate confirmation 4 times in less than 9 years, perhaps more than any other person during a similar period of time. Judge Thomas has also served as an Assistant Attorney General of the state of Missouri under our distinguished colleague Jack Danforth. He has also worked in the private sector as a lawyer in Monsanto Company's legal department. So I share President Bush's view that a justice of the Supreme Court of the United States should interpret the law according to the original meaning and not legislate his or her own policy preferences from the bench. And based on a careful review of Judge Thomas's writings and judicial opinions and my personal knowledge of the man, I am confident that Judge Thomas will interpret the law according to its meaning rather than substitute his own policy preferences for the law. I'm also confident that Judge Thomas will zealously safeguard the principle of equal justice under law for all Americans, not just white Americans, not just black Americans or Hispanic Americans or Asian Americans, but for all Americans without unfair preference. Judge Thomas' opinions also indicate that he's a sound law and order jurist, tough but fair to criminal defendants. Those who have known Judge Thomas over the years know that Judge Thomas is a man of fierce independence. When he is confirmed, he will be nobody's man but his own, as I know he has been throughout his life. That I know. And the judge's independence is not bounded by ideology. For example, when asked his views about establishing enterprise zones in inner cities, a principal element of conservative urban policy, Judge Thomas politely poured cold water on the idea. In so doing, here is part of what he said in 1985. Quote, "The first priority is to control crime. The sections where the poorest people live aren't really livable. If people can't go to school or rear their families or go to church without being mugged, how much progress can you expect in a community? Would you do business in a community that looks like an armed camp, where the only people who inhabit the streets after dark are criminals? There were lots of black businesses before enterprise zones, but blacks cannot stay in business if they are mugged, or if customers are mugged going in and out of the establishment, or if people are hanging out selling drugs in front of it. If you want to encourage business in these areas, then stopping crime has got to be at the top of the list," unquote. Now, Judge Thomas's independence, however, does not sit well with some special interest groups and some liberal academics and pundits. These critics would like to impose their liberal policy agenda on the American people through the judiciary. They fear Judge Thomas will be faithful to the Constitution and federal laws as enacted instead of to their political agenda. We've heard criticism from some groups that Judge Thomas isn't strong on civil rights. Nonsense. Judge Thomas has an excellent record on civil rights and a deep personal commitment to equal opportunity. As he wrote in 1986, quote, "I'm a black Southerner. I grew up under the heel of segregation, and I have always found it offensive for the government to treat people differently from others because of the color of their skin," unquote. At his confirmation hearing just last year for the judgeship he now holds, Judge Thomas testified, quote, "The reason I became a lawyer was to make sure that minorities, individuals who did not have access to this society, gained access," unquote. He took over the chairmanship of the Equal Employment Opportunity Commission in 1982 that had been in a shambles by his Carter administration predecessors. The Washington Post, no shill for the Reagan administration's civil rights record, praised, quote, "the quiet but persistent leadership of Chairman Clarence Thomas," unquote, in an editorial on May 17, 1987 entitled, quote, "The EEOC is thriving," unquote. The July 15, 1991 U.S. News & World Report wrote, quote, "Overall, it seems clear that he left the EEOC in better condition than he found it," unquote. He has favored strong remedies for discrimination, including many affirmative steps, such as increased recruitment and outreach to minorities and women. This is the kind of non-discriminatory affirmative action which we all favor. No, it isn't his civil rights record that these liberal critics are really concerned about. That is just a smokescreen. These critics really object to Judge Thomas having spoken out against what is popularly called reverse discrimination. He has, on a number of occasions, voiced his objections to preferences, to numerical devices, whether labeled quotas, goals, or set-asides. And this is the kind of affirmative action which is discriminatory itself. Here's one way he's put his views, quote, "I am proud to defend the principle that people should be judged on the basis of what they can do, not on the basis of irrelevant personal characteristics. Some believe that the laws should be read to prohibit only some discrimination and to permit or even require other discrimination. The prohibited and permitted types of discrimination to be determined apparently by the governing elites. Since the memory of when the governing elites favored discrimination against black people is still so clear in my mind, I prefer not to leave to the elites the discretion to categorize race discrimination into permitted and prohibited classes. All discrimination must be prohibited, unquote. Now, just as our society had finally enacted long overdue laws to prohibit racial, ethnic, and gender discrimination, new forms of discrimination were invented, ostensibly in the name of civil rights. Innocent persons were made new victims of discrimination as a purported means of remedying discrimination against others, and a redress for the history of these new victims, for the history which these new victims had not created. Now, we all know that discrimination and bigotry still persist in this country. It's a shame. Indeed, a tiny portion of my mail regarding Judge Thomas is another unfortunate reminder that some people in this country want to keep black people down. One satisfactory result of Judge Thomas's confirmation of the Supreme Court for this Senate will be the powerful rebuke it delivers to these un-American bigots. But the answer to discrimination is to end it, make whole its victims, take steps to ensure that it does not recur, and require the guilty party to recruit more minorities and women into its applicant pool and consider them fairly, along with the rest of the applicants. The answer is not to engage in discrimination against other innocent persons. Two wrongs do not make a civil right. The overwhelming majority of the American people favor equal opportunity, not equal results, not preferences for or against anyone because of their race, ethnicity, or gender, not reverse discrimination. They are well familiar with the variety and scope of the devices, however euphemistically labeled, used to embed preferences and reverse discrimination in employment and elsewhere. The advocates of preference and reverse discrimination know that these policies are extremely unpopular with the American people. Accordingly, supporters of these unfair policies couch their attacks on Judge Thomas in other language. Thus, they criticize him for his, quote, civil rights record, unquote, or alleged lack of sensitivity, or for being against all affirmative action rather than only the preferential unfair aspects of affirmative action, as reflects his true position while in the executive branch. In my view, it is really the judge's expressed belief in the equal rights of all Americans that some of these critics are really upset about. Now, I do not know how Judge Thomas will vote on specific aspects of affirmative action. As a Supreme Court justice, he will be in a new and a unique role. But because he has spoken out while in policy-making positions against preferences and what has been popularly known as reverse discrimination, the supporters of these unfair policies want to punish him. I trust, however, that the Senate will not sacrifice Judge Thomas on the twin altars of preferences and reverse discrimination. I will not dwell on my frequently expressed concern that the Senate has been infringing on the independence of the judiciary when it seeks direct or indirect commitments on specific legal issues from judicial nominees. Issues in the courts must be resolved in the courts. This judicial resolution should occur after parties have presented the facts of a specific case, deployed their legal arguments for the judges to consider, and the judges have done their own research and internal consultation. Such issues are not to be decided based on what a nominee tells a Senate committee in advance. Confirmation of a nominee should not turn on a commitment to prejudge an issue. I do wish to express two special concerns about this nomination process. Some interest group advocates of particular policies want this committee to insist that Judge Thomas answer questions and meet certain litmus tests, such as on abortion. The Judge Souter did not answer or meet just 1 year ago. 1 year ago this week. Last year, we were told that Judge Souter held the key to Roe versus Wade, yet virtually no one in the Senate made his discussion of that issue a condition of their vote. Now Judge Thomas is before us, and some would have us believe he now holds the key to Roe versus Wade. I note that Judge Thomas casts only one vote, not 5. It is inappropriate enough that he is expected to answer some of the questions Judge Souter did not answer. But if Judge Thomas is held to a higher standard and even more rigorous litmus test than Judge Souter, I think many Americans will be deeply troubled and will want to know why this particular nominee is being singled out at this time. Moreover, we are here to determine Judge Thomas's fitness to be a justice of the Supreme Court, not to conduct oversight on the EEOC or the Office for Civil Rights. We are not here to test his memory on events and documents constructed years ago. I would also note that after every matter in which Judge Thomas was involved in the executive branch, this Senate later confirmed him to a very responsible position at least once, and in some cases, 3 times. Finally, I just wish to mention my own delight at Judge Thomas's success. That success says a great deal about our country and about Judge Thomas, the man. Having grown up in the era of Jim Crow and gone barefoot in the unpaved street of his community, he will soon be able to put his feet under the bench in the highest court in this land as he contemplates the finer points of the law. I understand this. I was born into a family where we didn't have indoor facilities either during the early years of my life. And I understand what it's like in this great country. And I have to tell you, Judge Thomas, I'm so doggone proud of you, I can hardly stand it. I think it's a terrific thing that you're nominated to this position, and I personally will support you with every fiber of my being. As you yourself said when nominated, only in America could such a thing happen. It's wonderful to be a citizen in this country, and it's wonderful to see you sitting there before us this day. And it just reconfirms what all of us already know. This is the greatest country in the world. Thank you, Mr. Chairman.
Thank you. Senator Metzenbaum has been kind enough to, I'm told, yield to Senator Leahy because he has an appointment with the President to discuss the next 5 nominees to the Supreme Court. So I will yield to Senator Leahy.
Thank you, Mr. Chairman, and I thank you, but I also want especially to thank Senator Metzenbaum because of the President's schedule. The time of the meeting is such that would not probably be able to make an opening statement if he didn't do that, and I appreciate the courtesy of both of you. And Judge Thomas, I'm pleased to welcome you and your family to these hearings, and I was delighted to have a chance to meet, albeit briefly, Mrs. Thomas this morning. We all know that if we read the Constitution, read the advice and consent process, that established by the framers of the Constitution a method of having us assure the fitness of Supreme Court nominees. And that really has to be the most important function this committee can serve. Is at such committee hearings as we're having right now that Justice Thurgood Marshall was approved for a seat on the court some 24 years ago. And you look at that distinguished career of Justice Marshall, you see him serving as an able guardian of rights, rights that affect the welfare of every man, woman, and child in this country, rights like personal privacy, rights like a woman's right to choose, or freedom of speech, or the separation of church and state, and school desegregation. Well, the issues that were decided during those 24 years and fought over during those 24 years are no less important today. The nominee who replaces Justice Marshall in the court is going to be with us long after many around this table today have moved on. When children born this year, become eligible to vote in the year 2009, Judge Thomas, if you're confirmed, you'll still be a relatively youthful 61 years old. So your nomination comes at a pivotal time in Supreme Court history. In a little over a year, 2 of the court's great defenders of individual liberties, William Brennan and Thurgood Marshall, have both retired. Now, their departure gives cause for public concern about the direction of the court, and that concern is certainly reflected in the hundreds of letters and phone calls I've received from Vermonters this summer. Many fear that we're witnessing the creation of a monolithic, a right-wing court that's going to favor the state and the power of the state and its bureaucracies over individuals and minority rights. Now, you speak passionately about individual freedom, and your concerns are well placed, for it is the courts, and preeminently the Supreme Court, that must defend those freedoms. Judges are often targets of public disdain because they rule according to the law. They don't rule according to popular opinion or public opinion polls. Now that takes courage, especially when decisions run counter to shifting political winds. Our founding fathers anticipated this by insulating judges from the majority will and granting them lifetime tenure. Laws may be made by majorities, but minorities are safe only if those laws are tempered by justice and a passion for the liberties of the individual. The next Supreme Court nominee that the Senate confirms must be dedicated to the proposition that personal freedom is the birthright of every single American. In exercising our advice and consent responsibility, we have to consider a nominee's threshold qualities of judgment, temperament, experience, intellectual distinction, and moral fiber. But having done that, which is sort of the basic bedrock, we look beyond that. And I think it's appropriate we probe a nominee's judicial philosophy. Does he or she have an expansive or a narrow view of the Constitution? Does the nominee regard the Constitution as a safeguard for civil rights and liberties, as it was for Thurgood Marshall and so many great conservative and liberal justices of the court? Or does the nominee espouse a narrow and guarded approach that ultimately limits the freedoms of all Americans? And finally, we have to assess a nominee's willingness to answer questions. No nominee should be asked to discuss cases pending before the court. I accept that. That's a given. Neither should a nominee feel free to avoid questions about established constitutional doctrine on the ground that a case on that subject may eventually come before the court. Far too much is at stake. The Senate and the public have a right to know what a nominee thinks about critical issues before that nominee is confirmed to a lifetime seat on the court. So let me make this very clear, Judge Thomas. In recent years, we've danced around the question of where nominees stand on a woman's fundamental right to abortion. Now, this is one of the burning social issues of our time. It is the single issue about which this committee and the American people most urgently wish to know the nominee's views. And yet the Senate and the nation have been frustrated by polite, albeit respectful, stonewalling. To the extent that Judge Souter declined to answer pertinent questions last year, I was disturbed, and I told him so. And in light of your warm praise for Louis Lehrman's essay arguing that all abortion should be unconstitutional, then I believe the burden is on you to explain that view. I will expect forthright answers from you. If not, then I'll have no choice but to assume that you agree with what Mr. Lehrman said. And Judge Thomas, let me also say that I look forward to getting to know you better in these hearings. I am impressed. I believe the country's impressed by the less traveled road that you've taken from Pinpoint, Georgia, to the threshold of the Supreme Court. Your self-discipline, your diligence, and your hard work are exemplary. At the same time, you must understand that your record and some of your writings trouble me. I have no clear idea of what your approach is to the Constitution. You describe yourself as conservative. Well, most Vermonters are conservative too. But Vermont conservatives believe first and foremost in limited government. A government that stays out of people's personal affairs, leaves us alone, understands what Justice Louis Brandeis described as the right to be let alone. But many conservative activists contend that justices should invariably defer to majority rule, somehow to put blind faith in the infallibility of whatever the legislature is. You were part of a White House working group on the family which went so far as to argue that the jurisdiction of the federal courts might have to be curtailed. Why? To ensure that the majority automatically rules. I think the model becomes my government right or wrong, and I find that a chilling abandonment of individual and minority rights. Let us never forget that history has been written time and again by those who dare to challenge conventional wisdom. And you often allude to what the Declaration of Independence calls the laws of nature and of nature's God. Well, natural law, we all know, is an elastic concept. It can be used to defend, but also to deny basic rights. And a famous case has been alluded to already at this hearing today. A famous case in the 1870s. One Supreme Court justice would have upheld a law in Illinois that barred a Vermont woman from becoming a lawyer. And why would this Vermont woman be barred from becoming a lawyer? Because under the laws of nature, according to this justice, women were granted the noble and benign offices of wife and mother. And that's it. He wanted to make certain we knew that natural law would never accept a woman as a lawyer. Now, that might seem like a very quaint and dated reference, but the natural law problem is anything but dated. It can be used to argue for or against rights like abortion and privacy. I want to know what natural law means to you, Judge. How would you use it to interpret the Constitution and the Bill of Rights? And I'll ask questions along that line. In the hearing this committee held last year to consider your nomination to the D.C. Circuit, you said that you were not, quote, someone who has had the opportunity or the time to formulate an individual, well-thought-out constitutional philosophy. Well, that's fair enough. I don't have any problem with that answer. Every nominee to the Court of Appeals need not come armed with a fully coherent constitutional jurisprudence. They have to follow what's already in the law, what's already from the Supreme Court. But nominees to the Supreme Court should be prepared to tell this committee and through us, the American people, how they're going to approach the Constitution and the Bill of Rights. And I'm troubled by your open admiration for those willing to deceive and defy Congress, and by the hostility you've demonstrated toward Congress, both in action and in words in your speeches. You've attacked Chief Justice Rehnquist's opinion that upheld the special prosecutor law for Watergate-style investigations. You have questioned Congress' power to enact civil rights legislation. You have repeatedly suggested that Congress has no business carrying out its oversight function, one of the most important functions of this body. Now, I have always considered the separation of powers to be the surest guarantor of the limited government you claim to prefer. So when you state a clear preference for executive branch power over congressional authority, that gives me some pause. And finally, I'm concerned about some of your ideological views. You have wholeheartedly endorsed the statement that America is careening with frightening speed towards a statist dictatorial system. Well, I can't accept that. And these words seem more than a little strange as we watch the unfolding drama of Eastern Europe and the Soviet Union, where countries that truly suffered under statist dictatorial systems throw off their shackles. And when they throw off their shackles, where do they look? They look toward a free and compassionate America as an example of how a democracy is run. But more disturbingly, your words strike me as the views of a combative hardline ideologue. The last thing I seek in a Supreme Court justice is ideology. I value intelligence and wisdom, compassion, a willingness to listen to all sides of an argument. I want someone on the bench who's going to give every litigant a fair shake without bias or predisposition of any kind. Ideological fervor plays no part in a judicial temperament. So I look forward to discussing these and other issues with you. I welcome you to these hearings. I hope that you will be forthcoming in your responses to the committee, because ultimately we have to make the fully informed recommendation to the Senate and to the rest of this country. I welcome you here, and Mr. Chairman, again, I thank both you and Senator Metzenbaum for the courtesy.
Thank you. Senator Simpson.
Thank you, Mr. Chairman. I see you're trying to throw me off of my usual pattern there. The tenor of my remarks were somewhat dependent upon the commentaries that might emanate from my friend and senior colleague from Ohio.
Attacked before attacked, but
thank you.
Give it a shot anyway, Senator.
I was citing there a natural law of the Judiciary Committee. Judge Thomas, we welcome you to this important step in this process. Some of my colleagues have already spoken very clearly of your impressive and truly inspiring life story. I will not reiterate those remarkable accomplishments, and yet they certainly do stir one. I would only point out a clear irony Congratulations, and because of your tremendously successful career to date, you now have the opportunity to be subjected to a very rigorous process that can be unpleasant and sometimes rancorous, but hopefully never unfair. I do not believe our chairman would ever allow that. And let me emphasize, these hearings can also be quite orderly and courteous and thoughtful, and I believe that was indeed the case when we heard testimony and comments from Judge Souter and Judge Kennedy before this committee voted to elevate them to the Supreme Court. On the other hand, I think Judge Bork might well choose to undergo a medieval torture chamber rather than to be presented again before this committee. And that was a very unfortunate situation in my mind, whether you liked him or whether you didn't. And so, Judge Thomas, unlike some previous nominees we have faced, and I think again in particular of Justices Kennedy and Souter, you're really not a great mystery to any of us. You've been here before the U.S. Senate 4 times. No one I can ever imagine would have that type of exposure before this committee. So, no mystery to us. You've twice been confirmed by the U.S. Senate here on the EEOC by this very committee. Then you, after extensive hearings before the Senate, we confirmed your nomination to the U.S. Court of Appeals for the District of Columbia Circuit. 4 times. Members of the Senate have voted for or against you, very few in the negative. What is different now, I suppose, will be told to us as being a, quote, higher standard, unquote. I think it will be really a higher degree of plain old politics. Nothing wrong with that, but I think we ought to stay with reality as to what it will be. There will be some witnesses who will appear after you who will be very critical of you, extremely critical. They certainly have that right to express any type of opinion they may wish. However, for those Americans who are not as familiar with your record as we are in the Senate, after 4 separate hearings, let me emphasize that some criticisms of you have already been well considered and rejected by the Senate. I think that's important to keep in mind. Some groups will be here to criticize your tenure as chairman of the EEOC or as director of the Education Department's Office of Civil Rights. This committee and the full Senate has had all of those criticisms squarely before us on more than several occasions, including one which was not of great record before the Senate Select Committee on Aging, which was a real rake-around job in ancient days. And not much came of that either. So we rejected all of those previously when we confirmed your nomination to the D.C. Circuit Court by a voice vote. I think there was a quite audible nay, perhaps, from one on the panel who is not a faint-hearted man and who speaks very clearly on the issues. So I would hope that this hearing does not simply dwell on all these previously thoroughly debated and already decided issues. That laundry has been well washed. Some critics will be here to say, and will say here, that the ABA found you to be only qualified for the Supreme Court. That's the American Bar Association. I assume some on that committee apparently would have preferred that you would have had more experience on the appeals court. But let us clearly remember that most of those in the ABA are of the same critics who opposed the nomination of Robert Bork, even though a majority of the ABA committee had found Judge Bork to be, quote, well qualified, unquote. So much for that. Let us also recognize the ABA rating for exactly what it is: helpful at times, irrelevant at others, and always subject to political manipulation and pressure of special interest groups within the bar. Yes, that does occur. Some special interest groups will be here to say some pretty harsh and even some very arrogant and patronizing and even nasty things about you from the testimony I can envision coming from them and some of the material I've seen. You might not even be able to recognize yourself when they're finished portraying you. I know that was the case with Robert Bork. I don't come back on that to express any unfairness by the chairman. There are many who feel the other way. That isn't even the issue. But what I saw happen, this senator from Wyoming, was we watched a man who had been on the federal bench for 5½ years, who had done and written 104 decisions, none of them ever overturned on appeal, and 6 of his dissents became majority opinions of the United States Supreme Court. And whether one liked him or not, he was portrayed to this committee and to the United States people as a gargoyle, a sexist, a racist, an invader of the bedroom, a sterilizer of women. I sat right here and watched it all happen. Very, very troubling procedure. So from what I've come to discern, you will also be portrayed by some as being hostile to privacy rights, as being an apologist for segregated schools, and a promoter of wild, dramatic, and unchecked theories of natural law. That will cause the U.S. Constitution to come undone at the seams. One writer, I think, who aspires to this court under some other administration, has said that the Senate cannot avoid sharing the responsibility for the fate of self-government in the United States. Pretty dramatic. I thought, as I heard the discussion, I think you might come to see that natural law will become but a pseudonym for natural opposition, or natural partisanship, or natural frustration at having to place an independent, thoughtful, bright conservative on the United States Supreme Court. That will become quite evident to the American public. Now, there is a natural solution for that. Elect a natural Democrat as President of the United States. The American public has not chosen recently to do that, but naturally they could. So, some groups have actually portrayed you as being hostile to civil rights issues, and that is patently absurd and demeaning and arrogant. It is clearly known you are a powerful supporter of anti-discrimination laws. We also well know that some groups are most afraid of some groups who do not like the fact that you oppose remedies which themselves cause reverse discrimination. When actually most types of reverse discrimination do indeed violate the Constitution, and most Americans really do strongly oppose reverse discrimination. So I believe these criticisms of you to be inaccurate and off base, and some writers, I think, have been, in some cases, somewhat hysterical. And one can be a fine and strong supporter of civil rights while being very strongly opposed to unfair preferences, and many here feel that way. I know I fit that category too. So, Judge Thomas, there will be a number of us here to listen, to seek the truth. If we're here just to hear some of the special interest groups parrot some of the old stale lines of criticism I've just recited, well, we have our opportunity to rebut that. But for now, I earnestly recommend that you sit back and relax as much as is possible. The chairman will handle it with equanimity and care and fairness, and allow the American public to come to know you in the same way that many of us on this committee know you. And through tough, hard, serious, and yes, even partisan questions by this committee, I believe all Americans will come to know you for what you are, an uncommonly bright, articulate, and qualified judge with significant and impressive legal and life experiences, who is ready, fully ready, willing and able to serve our country on the nation's highest court. And let me conclude by saying that not only do I believe you will be good for the Supreme Court, but Judge Thomas, I think you will also be very good for America on the broader level. And you yourself have noted at some risk, obviously, that there are too many people today giving groups excuses for various things that happened in their lives. I'm not even going to comment on that. You can. You have. But I think the last thing anyone needs right now in this country, white, brown, yellow, or black, is more excuses for everything. Excuse time is over. It is important to run out of scapegoats. It's time for all Americans, and that's what we are in this pluralistic society, to focus again on what has made this country great. And we must all reacquaint ourselves, all of us, every race, color, and creed, with those distinctly American and yes, even corny notions of hard work and decency and kindness and fairness to our fellow humans. And we must strive to provide every single individual with an equal opportunity to realize his or her full potential. You exemplify what all of us might be able to accomplish, good things if we were to stop making excuses, and I was awfully good at that. I was known as Alibi Al in high school, and it worked. I could fake anybody out except myself. And finally, creeping maturity overcame me, and there was some progress. So you are an inspiration to us all, and Mr. Chairman, I thank you, and I sincerely welcome Judge Thomas to our committee, and I thank you for your past and present courtesies.
I thank you, Senator, for once again not disappointing, and I think you'll soon find out that Judge Thomas's views are so different from Judge Bork's, if anything he wrote means anything, that you'll be dumbfounded that this is not about conservatives. This is about how people think.
I have an opportunity for rebuttal. Thank you.
Senator Metzenbaum.
Thank you, Mr. Chairman. Judge Thomas. This is the 5th Supreme Court vacancy in the Reagan-Bush era. Once Justice Marshall's seat is filled, Presidents Reagan and Bush will have filled a majority of seats on the Supreme Court. A judicial nominee cannot become a member of the High Court simply because the President and his advisors are comfortable with that nominee's views and judicial philosophy. The Supreme Court is not an extension of the presidency. The Constitution makes it clear that the Supreme Court is a separate and independent branch of government. That same Constitution assigned the Senate a role in the confirmation process to help preserve the independence of the judiciary. The importance of the Senate's role has grown in recent years because, quite frankly, Presidents Reagan and Bush have made no bones about using the court to advance their political and social agenda. A core element of the Reagan-Bush political program has been reversal of Supreme Court decisions in the areas of abortion, civil rights, individual liberties, and the First Amendment. The Reagan and Bush administrations have used the courts to achieve policy outcomes on social issues which they could not obtain through the legislative process. Make no mistake about it. The Reagan and Bush administrations have succeeded. You only have to look at the court's astonishing decision last term in the abortion gag rule case to realize that the Rehnquist court is intent on implementing the Reagan-Bush social agenda. An omen of things to come from the Rehnquist court was contained in a paragraph in Payne v. Tennessee, a 1991 case in which the court reversed itself on a question of constitutional liberties. The majority in that case stated that adherence to precedent is most important in cases involving property and contract rights. But with respect to constitutional rights and liberties, a majority of the Rehnquist court stated that adherence to precedent, quote, is not an inexorable command, particularly in constitutional cases, end of quote. In other words, the Reagan-Bush Supreme Court thinks that justices should be more respectful of precedent when a business person's contractual rights are at stake than when a woman's constitutional right to choose or an African American's right to equal treatment is at stake. As Justice Marshall wrote in his dissent in Payne, This statement by the Reagan-Bush court sends, quote, a clear signal that scores of established constitutional liberties are now ripe for reconsideration, thereby inviting open defiance of our precedents, end of quote, by Justice Thurgood Marshall. It is in that context that the current nominee comes before the Judiciary Committee. The nomination of Judge Clarence Thomas has provoked debate and differences of opinion throughout the country. But there is one thing upon which everyone, including this senator, agrees. Judge Thomas's life story is an uplifting tale of a youth determined to surmount the barriers of poverty, segregation, and discrimination. It was an extraordinary journey from hardscrabble Pinpoint, Georgia, to the promise and privileges of Yale Law School. It would be easy and probably smart politically for senators to vote in favor of this nomination because of Judge Thomas's personal triumph over adversity. Frankly, I suspect the President and his advisors believe that some senators will do just that. But the Senate must evaluate the nomination based upon the career and record of the nominee, Judge Thomas. The question for this committee is not, where does Judge Thomas come from? Rather, the question for the committee is this: where would a Justice Thomas take the Supreme Court? I am deeply concerned about the answer to that question. The record suggests that Judge Thomas may be an eager and active participant in the Rehnquist Court's assault on established judicial precedents which protect civil rights and individual liberties. Judge Thomas has harshly criticized important court decisions which have protected voting rights for blacks and promoted equal treatment for minorities and women. Indeed, he has suggested that many of these decisions should be overturned. Virtually every public statement which Judge Thomas has made regarding the issue of abortion indicates that he does not believe the Constitution protects a woman's right to choose. Indeed, Judge Thomas even signed on to a White House report which urged the appointment of new Supreme Court justices who would overturn decisions such as Roe v. Wade. There are those who suggest that because of his extraordinary background, Judge Thomas will bring a different perspective to the court. That may be true. It also may not be true. I am concerned that the nominee's statements and record indicate that rather than bring a different perspective to the court, he will fit in all too well with a court that has spurned its special duty to protect the rights of women and minorities, the elderly, and the poor. During his tenure as chairman of EEOC, Judge Thomas failed to fulfill his duty to protect the rights of older workers. Now, some argue that this failure as EEOC chairman is irrelevant in determining his qualifications for the court. I believe that his disregard for the rights of older workers is very relevant. It directly relates to his sensitivity and to his duty to provide judicial and constitutional protection for the aged. Unfortunately, while Judge Thomas was head of the EEOC, thousands of older workers who believed that they were victims of age discrimination lost their right to bring age-biased suits in federal court because his agency failed to process their claims in a timely manner. Despite assurances from Clarence Thomas that he would correct the problem, Congress found it necessary in 1988 and again in 1990 to pass legislation to restore the rights of these older workers. In his career with the federal government, Clarence Thomas was appointed to jobs designed to protect and enforce the rights of the disadvantaged. Yet in speech after speech, Clarence Thomas rails against governmental efforts to aid minorities and the disadvantaged. In one article, Judge Thomas even asserted that it was, quote, insane, end of quote, for African Americans to expect the federal government to help relieve the harmful effect of decades of discrimination. Judge Thomas benefited both from affirmative action and from the work of civil rights leaders and government officials who have tried to break down the barriers of poverty and discrimination. Yet Judge Thomas condemns government efforts to give other people the same chance he had to climb over those barriers to success. One other area of concern is Judge Thomas's constitutional philosophy. Judge Thomas's speeches and writings suggest that he might read the Constitution as forbidding the minimum wage law, banning affirmative action, and severely restricting constitutional power. In addition, Judge Thomas has asserted that the Constitution must be interpreted in light of natural law. As has already been pointed out, natural law is a broad, vague concept which means different things to different people. Over 50 years ago, conservative judges used natural law arguments to uphold anti-union practices by employers and strike down health and safety legislation. Similarly, a 19th century Supreme Court decision relied upon natural law arguments about the paramount destiny and mission of women to justify an Illinois law which banned women from practicing law. Today, anti-abortion advocates have cited natural law as their basis for their argument that a fetus has a constitutionally protected right to life which overrides a woman's right to choose. In 1987, Judge Thomas called one article which made that argument, quote, a splendid example of applying natural law, end of quote. So, Judge Thomas, I begin this hearing with a great deal of respect for your accomplishments, but also with a great deal of concern about your record and about the direction in which the court has been moving. You have been nominated for a seat on the Supreme Court which can no longer be counted on as a force to promote racial harmony, equal treatment, and social justice. A majority of the Supreme Court has taken a sharp right turn and declared open season on a number of constitutional liberties and civil rights which Americans hold dear. While the President may celebrate the court's movement in this direction, I lament it. Ultimately, Judge Thomas, I must examine your record and determine whether you will be a justice who will accelerate this movement or a justice who will help to restore balance to the court. And once again, make it a force for equal justice, fair treatment, and individual liberty. Thank you, Mr. Chairman.
Thank you very much. Senator Grassley.
Mr. Chairman, I want to thank you for scheduling this hearing so soon after the recess is over, so that we have an opportunity to get through this and to get Judge Thomas sworn in and serving on the court when it opens its fall term. So thank you, Mr. Chairman. Congratulations, Judge Thomas. And I welcome you, and primarily I want to also welcome your family. This is for you and for us on this committee, a really historic moment because there have been only 105 Supreme Court justices since the Supreme Court was set up in accordance with the Constitution. So that will put you, Judge Thomas, in a very small, prestigious group. But somehow I feel it's a group that you have prepared yourself for diligently. I hope that my fellow Americans know that Judge Thomas has served with distinction in both federal and state governments. At the federal level, he has substantial experience in all three branches of government, and I would venture to guess that few nominees have ever had such a breadth of experience before being nominated to the highest court in the land. I would hope that this background has given Judge Thomas an appreciation for the appropriate role of courts that they have within our democratic government. Our American governmental system is, of course, a delicate one, with a structure of checks and balances and defined roles for each branch of our government. Sometimes justices haven't always understood that they are not policy makers. For example, some have criticized Judge Thurgood Marshall for continuing to be an advocate even after he donned the robes of an umpire. One of the architects of Article 3, Alexander Hamilton, wrote that the courts must declare only the sense of the law, and if they should be disposed to exercise will rather than that judgment, the consequence would be the substitution of their pleasure to that of a legislative body. To be faithful to our Constitution's framers, Judge Thomas will actually be required to step back from his past involvement in the shaping of public policy. Being a judge, as he has said since assuming his position on the Court of Appeals, he says it requires discipline. Rather than making policy, he will be called upon to interpret the policies of the elected branches of government, of course, all the while guided by the Constitution. This confirmation hearing will give the Senate and at the same time the American people the chance to become acquainted with Judge Thomas and to assess whether he possesses the qualities that a justice should have: fairness, open-mindedness, and objectivity. I expect that we will all see an individual unlike any other who has come before us as a nominee for the High Court. Judge Thomas spent the first 17 years of his life in strict segregation of the South, directed as to what water fountain he could drink from and what public restroom he could use. Judge Thomas has described this, and I quote, as close to totalitarianism as he would ever hope to get, end of quote. He grew up without material comforts and even conveniences. We've heard from him and people who have known him well that it wasn't until he was 7 years old that he lived in a home with indoor plumbing. His home was run quite strictly by his grandparents, who in his words had PhDs in life, earned at the University of Experience, with hard times as their advisor. They instilled in him discipline and respect. It seems to me like discipline is a shortcoming of too much of American society today. So having that in Judge Thomas puts him a cut above average American society. He was inspired by his grandfather and his teachers. They were Catholic nuns. They gave him his personal foundation: God, values, morality, and education, and these are the words that he told the nuns when he paid tribute to them in 1986. In the Senate, we have some who have started from humble beginnings and many who were born into great wealth and privilege. None of us, however, has had to surmount the obstacles Judge Thomas has confronted: racism and prejudice, from his cruel teenage classmates in the seminary to supposedly enlightened employers he encountered as a young law school graduate. As he's noted, he's been deterred and preferred by racially conscious policies. Many others with his experiences would become cynical and selfish, I'm sure. But rather, we have before us in Judge Thomas a man who has devoted his professional life to work on behalf of equal rights and opportunities for all individuals. He sees the respect for individual rights as a great and overriding tradition of our nation. What's most important, and he knows while saying that there's still a lot of work that needs to be done in this great country of ours. Now, some find Judge Thomas to be threatening because he challenges the liberal orthodoxy of special preferences and group entitlements. That has become, as columnist William Raspberry has said, black political orthodoxy. But Judge Thomas's message of self-reliance is a reminder to all Americans that while government's responsibility is to ensure equal opportunity, reliance, let me say too much reliance upon government-mandated preferences won't solve each and every problem. Now, we will have the opportunity in the next few days to explore many topics with Judge Thomas. However, he is no stranger to the Senate, and I think I'm the fourth person this morning who has said that he has been before this confirmation process of the Senate on 4 separate occasions, and I guess this is the 5th one. Moreover, I think that Judge Thomas, in many different ways, both in public and before this body, has already been very forthcoming. In response to the committee's request for certain documents, Judge Thomas has provided, I've been told, some 36,000 pages of documents. And I understand that it has been cataloged in some 10 boxes of documents. Now, I don't know. I suppose there could be others because we confirm a lot of people, but I really don't know of any other nominee who has been so scrutinized and so analyzed as you have been, Judge Thomas, in preparation for this hearing. This document request is just an example of how far the Senate has strayed in the nomination process. I suppose I say that in a historical context. Some have stated that the Senate's advisor and consent role in the elevation of Supreme Court justice, of any Supreme Court justice for that matter, is the most important power that we in the Senate here exercise. Now, I don't happen to share that view as important as I take my responsibilities today and through this process, because I happen to feel that confronting the issue of war, as we did only last January, and attempting to bring government spending under control are among the more significant responsibilities that we have. And of course, I think the Constitution doesn't quite elevate the confirmation process quite this high as the Constitution indicates in the advise and consent role, because it is spelled out in Chapter 2 with executive powers and not with the legislative powers in Article 1. So I think the Constitution itself kind of says it's not a preeminent legislative power. It's really only in recent years that the Senate has redefined its role. When Justice White was nominated just 29 years ago, he came to this Judiciary Committee and was asked only 8 questions. What has changed to require all these long hearings over the last quarter century? Well, something has lengthened the process, and to some extent I feel it's been lengthened needlessly. I don't know exactly why, but this is how the process works today, and I'm a member of the Senate, and I'm going to make sure that the process works, but I think once in a while maybe we ought to take some, reanalyze how we do things. And of course, saying this doesn't mean that the Senate should be a rubber stamp. I don't believe that. Judge Thomas, I look forward to talking with you over the next few days about the role of the courts in our democracy, how you approach cases, and the differences that you see between judicial restraint on the one hand and judicial activism on the other hand. And I will have some questions for you, like I'm sure you've indicated. A lot of my colleagues are going to have questions about how you see this whole issue of natural law. We should also have an understanding as to whether you bring a very personal philosophy to the job and the responsibilities of judging. Finally, Judge Thompson, I wish you well in the process which lies ahead. And I caution very much against a quest for commitments on very specific issues, particularly issues that will come before the court. For if you were to lay out any particular positions on the legal issues of the day, the independence and the integrity of the judiciary that you're now a part of and will rise in shortly, I hope, you'll be compromising that integrity and independence, and you have to be a policeman for that integrity and independence. We expect you to do, and I believe that you have been already. Thank you.
Thank you very much, Senator. Senator Heflin.
Thank you, Mr. Chairman. I'd like to welcome you, Judge Thomas, to this historic confirmation hearing. Your nomination by the President is a continuation of a constitutional process begun over 200 years ago. A few duties that I take more seriously than the advise and consent function entrusted to the members of the United States Senate. As I have with every nomination hearing, I will use this occasion to listen and learn. Through the media, we've all seen and heard and read a great deal about this nomination and its uniqueness. But it is during these hearings where spontaneity and unpredictability are common that those of us charged with the duty of advise and consent are able to make an informed decision. I've often stated that the Supreme Court is really a people's court, where while the court deals with such abstract legal principles as justiciability, collateral estoppel, comity, due process, and so forth, the court must ultimately deal with real people, their rights, duties, property, and most importantly, their liberty. The justices of the Supreme Court are the final guarantors of the sacred text of the Constitution and its Bill of Rights and the liberties and freedoms which are enshrined therein and developed therefrom. If confirmed, you will have vast power over the lives of Americans as to their rights of speech, religion, press, association, as well as their property rights. You will participate in decisions which will affect the rights of those accused of a crime, as well as the rights of a lawful society to be protected from the criminal element. And you will have an important say as to what degree of privacy the American people are entitled. The list could go on, of course, but my point is that before we are called on to exercise our confirmation function, we in this Senate must explore what is in your heart and what is your basic judicial philosophy. Because if you're confirmed, you'll serve a lifetime for perhaps the next 30 years, thus well into the 21st century. We, on behalf of the American people, must investigate if you will zealously guard the freedoms and the liberties that provide a legacy and framework for generations to come. In reviewing the qualifications of a nominee, I'm of opinion that an individual should possess at least the following three criteria. First, an understanding on the proper role of the judiciary under our Constitution. Second, an abiding belief in an independent judiciary. and third, a deep commitment to equal justice under the law. To some, you are the very embodiment of the American dream. You have overcome the bonds of poverty and racial segregation and deprivation and have risen to the top. To others, you have succeeded but forgotten your past and turned your back on others now less fortunate than you. I and my colleagues will attempt to look into your heart and mind. I will be looking to see if you intend to bring a rigidly ideological agenda to the court. I will want to know if you respect the principles of stare decisis and judicial restraint. And most importantly, if you intend to turn the clock back on almost 30 years of racial progress and harmony which has occurred, albeit imperfectly, in the diverse society known as America. Under the advice and consent function, it is our solemn duty to explore any doubts about you and your thinking. The theme of this hearing could be entitled Doubting Thomas. The term Doubting Thomas has been applied to individuals from biblical times to the present, but it is applied today in a different context. You are not the doubter. It is we in the Senate who are the doubters. This hearing can remove, clarify, increase, or decrease the doubts and the doubters. There are many who have expressed doubts that you are sensitive to equal rights and equal justice under the law for all Americans. Doubts about your commitment to achieving the legitimate aspirations of all Americans from whatever walk of life and regardless of their political persuasions. Doubts about your concept of natural law, its standards, restrictions, breadth, and application. Doubts as to whether your judicial thinking is within the mainstream of judicial thought, and many other doubts as well. Judge Thomas, if the Senate is persuaded that you will pursue an ideological agenda, have a closed mind, and will be a judicial activist ignoring the will of elected bodies, then the doubts will become impediments to your confirmation. On the other hand, if your testimony persuades us that you will dispense justice fairly and impartially, and that you will listen and be open-minded, then in my judgments, doubts will be alleviated. President George Washington told his first Attorney General, Edmund Randolph, the administration of justice is the firmest pillar of government. And if justice is the ultimate goal and indispensable for the survival of a free republic, we best ensure it by the people we select as its custodians. We will now have the opportunity to learn if you are worthy of that admonition, and I look forward to hearing from you. Thank you.
Thank you very much. Senator Specter.
Thank you, Mr. Chairman. Judge Thomas, I join my colleagues in welcoming you here this morning. I have read extensively on your opinions and your speeches and your background, and I congratulate you on a very remarkable career. As I have read about your roots and about the instructions and guidance which you got from your grandfather, I couldn't help but think that your grandfather and my father would have been good friends. You have really pulled yourself up, perhaps without bootstraps, perhaps by your kneecaps, and you come to the Senate for what we have an obligation to do is a very careful analysis of your background and record, as we will attempt to make an evaluation as to what kind of a Supreme Court justice you would be if confirmed. The importance of your nomination is overwhelming. At the age of 43, if you serve as long as Justice Thurgood Marshall did, that would be until 83 or 40 years, which is the equivalent of 10 presidential terms. And when you consider that in the last Supreme Court session, out of 121 decisions, that 18 were decided by
a 5-4 vote where the court is on the cutting edge of the most important issues which confront our country, a justice who can provide that fifth vote for 40 years, 10 presidential terms, may really be more important than a president. The opening statements, Judge Thomas, I think are useful to give some idea as to what the individual senators think are important as we proceed with the questioning. And a major concern that I have involves the functioning of the court as a super legislature. You have already heard many say that we want the laws interpreted and not made. And I'm concerned by a major case on federalism handed down by the Supreme Court in 1984, where two justices in the minority on a 5-4 decision said they only awaited a fifth justice to change the complexion of the court so that the case could be reversed, placing ideology at the forefront. And I'm concerned about, and I could cite many cases, but only one more within the confines of limited time here, the interpretation of the 1964 Civil Rights Act. In 1971, a unanimous Supreme Court, with an opinion written by Chief Justice Burger, a noted conservative justice, interpreted the Civil Rights Act in a very meaningful way. In 1989, that decision was changed as a matter of judicial interpretation, even though the Congress of the United States had allowed that decision to stand for some 18 years. 4 of the justices who voted to change the law, not to interpret the law, but to change the law, have appeared before this committee during the past decade and have placed their hands on the Bible and have said that they would not make new law, but only interpret the law. But they changed a view of congressional intent in the context that Congress allowed that law to stand for some 18 years. I think it is fair to take a look at your writings and your decisions as a basis for questioning. I do not believe that you ought to be called upon. I say this speaking for myself because there are no conclusive parameters to what a senator may ask, but I do not believe you ought to be asked for the ultimate decision as to how you will decide any case. Because in our judicial process, that really calls upon a specific statement of facts, briefs, arguments, deliberations among the justices, and then a decision. But as I read through your writings, Judge Thomas, and take a look at what deference you will give to constitutional process and the congressional will, as I evaluate your judicial temperament in carrying out congressional will, I have noted a number of your writings, and this is not in isolation but illustrative of one of your speeches, that you say Congress is no longer primarily a deliberative or even a lawmaking body. There is little deliberation and even less wisdom in the manner in which the legislative branch conducts its business. Now, I have noted your critical view of the Congress that would pass an ethnic set-aside law. I have noticed your critical view of a major case interpreting affirmative action in a context where the Congress could have changed those decisions but did not. And I have noted your recognition of the Congress leaving those cases constitutional continuum in that context. At one point in your writings, although you don't endorse it as a conclusion, you refer to a quick fix of additional Supreme Court nominees. In another place, you talk about the preference of having additional nominees change the minority opinion into a majority opinion. And I believe that these are important issues as we see the role of a nominee, a prospective Supreme Court justice, and a critical role as to whether we may expect you to interpret the law, which I believe is the role of the court, as opposed to making new law. In terms of the questions which are appropriate to ask you. That has been an evolving matter. And there's a fascinating article written by Chief Justice Rehnquist when he was a lawyer in 1958, which admonished the Senate in the confirmation proceedings for Justice Whittaker for asking mundane questions about his experience as a skunk trapper and the fact that he brought honor to 2 states, being born in Kansas and being appointed from Missouri. And Chief Justice Rehnquist admonished Congress, the Senate, for not really going into the very substantive questions on equal protection of the law and due process of law. And when we come to the question of separation of powers, that is rock bed in our society, and the Senate has a duty to make an independent evaluation. I, for one, continue to believe that deference is due to the President's nomination. But even that could be subject to question, Judge Thomas, if the trend of the court continues as a super legislature establishing policy. And there has already been some discussion here today, and I think it is worth noting that an early draft of the Constitution gave the Senate the authority to appoint Supreme Court justices. And going back to Chief Justice Rehnquist's observations in 1958, he's very pointed in approving an editorial which said that the Senate would have the authority, if it chose to exercise it, to insist on balance on the court. As I say, I, for one, believe that at this point in our constitutional evolution, we have not come to the point of equal partnership between the President and the Senate, so the deference is still owed to the President. But this could be a more complex question if the court continues to function as a super legislature. The issue of affirmative action, I think, will be very important in these hearings for 2 reasons. One is to test your own development as a lawyer and your own philosophy of life, your philosophy of law, your philosophy of justice, because at one point you had sanctioned affirmative action in terms of standards and goals, and there has been a change in your thinking, and you're certainly entitled to that, but I think that is an issue which will bear some scrutiny. I have noted in your writings, Judge Thomas, your conclusion that the Dred Scott decision, which upheld slavery, and the opinion of Chief Justice Taney put a backdrop of racism and discrimination which are deeply rooted in the history of the United States and remain even to the present time, which is a very strong statement. And unfortunately, I agree with you. I think it is an accurate statement about racism and discrimination. And I noted your comment on a fairly recent writing about you, the Atlantic Monthly by Mr. Juan Williams, quote, "There is nothing you can do to get past black skin. I don't care how educated you are, how good you are at what you do, you'll never have the same contacts and opportunities. You'll never be seen as being equal to whites." And that, again, is a very strong statement, and it raises the question in my mind as to whether we should be promoting affirmative action. And I think our discussion here will move far beyond the surface labels of what are quotas, which we hear so much about today, and what affirmative action really means. And I know that there are some who are critical of any person who takes the benefit of affirmative action and then rejects it for others. And I've read the newspaper accounts. I don't know firsthand whether you were the beneficiary of affirmative action. But even if you were, you may be the best witness on the subject to really delve into this issue, which is on the cutting edge of one of the most important issues facing our society today, and that is equality of employment opportunity. Beyond these issues, Judge Thomas, there are many, many other questions which we're going to have to go into. Senator Grassley commented, the war powers issue, a big one. We just went through a heated debate just a few months ago, which involves the question as to the Congress's authority to declare war versus the Commander-in-Chief's authority, the President's authority as Commander-in-Chief, very big issues on freedom of speech, freedom of religion, the Exercise Clause, the Establishment Clause, so that I think we will have subjects of really great importance, and I approach this hearing totally with an open mind. Speaking for myself, and others have disagreed, have already announced positions, I believe that separation of powers calls for independence of the Senate. Repeating, as I already have said, a deference to the President's views. But I think we ought to listen to you carefully, in a very friendly way, in a very constructive way, and hear out the other witnesses before coming to a judgment of the case. Thank you, Mr. Chairman.
Thank you very much, Senator. Senator Simon.
Thank you, Mr. Chairman. And Judge Thomas, I join in welcoming you and your family here. No responsibility this committee faces is heavier than the decision on a nominee for the Supreme Court. That is always true, but its truth is underscored when the retiring justice is 83 and the nominee is 43. There are nominations for high positions, such as a cabinet member, to which all of us in the Senate resolve limited doubts in favor of the President. Doubts in the case of a Supreme Court nominee must be resolved in favor of protecting the public. While there are some who are looking for an outstanding legal scholar for the nomination, such nominations have been rare in the history of the court, though when that has happened, the nation benefited. The American Bar Association rating of the nominee is not high, but among those who have developed into superior justices are people whose legal background cannot be characterized as stellar. My conclusion is that the nominee has the basic ability to make a good justice, and the fact that he is an African American brings diversity to the court. That is a plus. But I have unanswered questions that these hearings should clarify. What is Judge Thomas's understanding of the role of the court? In criticizing a 6-3 Supreme Court decision, Johnson v. Transportation Agency, on the employment rights of women, the nominee applauded Justice Scalia's dissent, which he has every right to do, but then said he hoped the dissent, and I'm quoting, would provide guidance for lower courts, end of quote. What did he mean by that? Does he believe the lower courts need not follow the lead of a majority on the Supreme Court? And a fundamental question the committee must weigh is, are we destabilizing the law by creating a Supreme Court that swings back and forth depending on the whims of an administration? While the history of the Supreme Court appointments often reflects the political philosophy of the President making the nomination, presidents have also considered the stability of the law in making appointments. And so Herbert Hoover named Justice Benjamin Cardozo. Dwight Eisenhower selected Justices Earl Warren and William Brennan. Richard Nixon nominated Justice Harry Blackmun, and Gerald Ford nominated Justice John Paul Stevens. And Democratic presidents appointed conservative court members. John F. Kennedy named Justice Byron White, and Harry Truman named a Republican senator, Justice Harold Burton. In each case, the president, at least once, nominated people who were of a differing political philosophy. At least 8 times in this century, presidents have nominated justices who were of a different political party than the president. The law has been well served through this balance. But in recent years, this sense of balance has diminished. Will the current nominee add to a balance or an imbalance? The law should not be a pendulum swinging back and forth depending on the philosophy of a president. And I am concerned that the court is shifting from its role of being the champion of the less fortunate. It is easy for any government to become too cozy with the wealthy and powerful. Once on the court, justices do not rub shoulders with society's unsuccessful at Washington cocktail parties and dinners. But the test of whether we are a civilized society is not whether we treat the elite well, but how responsive we are to those who do not have the political or financial reins of power, the least fortunate among us. The nominee has, to his great credit, overcome major obstacles to be where he is today. But what about those who have been less fortunate or less able in overcoming obstacles? What does he mean when he writes, and I quote, "I do not see how the government can be compassionate. Only people can be compassionate, and then only with their own money, their own property, or their own effort, not that of others." End of quote. I join Judge Thomas in lauding self-help, but not to the exclusion of government's proper role. Does Judge Thomas mean that we should not have student aid programs, a Head Start program? Does that suggest there is something unconstitutional or morally wrong with government seeing to it that no one falls through the cracks in our health care delivery system? Was government not compassionate when we passed federal legislation outlawing segregation? Yes, it affected the property rights of hotel and restaurant owners and many others, but does anyone really believe that this government action was morally wrong? Was this comment of the nominee a throwaway line, or does it suggest a philosophical mindset? And aside from the natural laws that have been referred to here, do the nominee's views differ in any marked respect from those of Judge Robert Bork, whom this committee rejected by a 9-5 vote? I'm also concerned with the erosion of basic liberties that is taking place on the present court. The Rust v. Sullivan decision is potentially the most significant assault on our basic liberties since the Supreme Court during World War II approved the federal government taking from their homes Japanese Americans who had committed no crime. If the logic of the Rust decision is upheld, that the federal government can restrict speech if it provides financial support, then libraries that receive federal support can be told what books they may have, and universities can be told what they may teach. This decision will be revisited both by Congress and the court. I do not expect the nominee to tell me how he would rule on Rust v. Sullivan, but I want to sense the philosophical moorings that will shape how he votes. A Thomas address that comments on the Ninth Amendment. Was it a casual speech like senators too often make, or does it accurately reflect his thinking? The court will soon make decisions on sensitive church-state issues. Where does the nominee stand on these traditions? Freedom is much easier to give away than to preserve. I want a nominee who understands not only the letter of our Constitution, but also the spirit of it. What does Judge Thomas sense is his mission on the court? That is the fundamental question we need answered to make our decision. Judge Thomas, in my opening statement for the Souter nomination, I used these words to that nominee that are just as appropriate today. I want someone to whom every American can look and say, there is a champion of my liberty. That should be true of men and women, the old and the young, the able and the disabled, for people of every region and religion and color and national background and station in life. That is an extremely high standard, but it is an extremely high court to which you aspire. Thank you, Mr. Chairman.
Thank you very much. Senator Brown.
Thank you, Mr. Chairman. Judge Thomas, it's a pleasure for me to also join the others on this committee to welcome you here, along with your beautiful family. I don't know how this committee will resolve the question before it as to your judicial competence, but in terms of your ability to be an excellent listener, I think you've already passed the test. I suspect a further trial is ahead of you, though, in that regard. You've perhaps enjoyed so much your other 4 Senate confirmation processes, you've been anxious to go ahead with a 5th. You come here before us as a husband, as a father, as a son, and a brother. I only hope at the end of this deliberation that your family feels that you've had a full and a fair opportunity to present your viewpoint. I think that's important for us to make the right kind of decision. Mr. Chairman, as we consider Judge Thomas for the position of the 106th Justice of our Supreme Court, we fulfill an important constitutional duty. Over the course of the next several weeks, the American people will have an opportunity to witness the 3 branches of our government coming together to fulfill those duties and to chart the course for our judicial history and future of this nation. I think it's important that we gather and do this job in a thorough manner that has been laid out. And we judge not only the nominee, but I think in some measure we judge ourselves as well. The American people are unique in the history of mankind. We're unique in our commitment to individual and personal rights. It is perhaps a phenomenon that the Constitution and its amendments deal as much with preserving individual freedom from the powers of government as they deal with establishing the very framework of that government itself. That approach or that uniqueness says a great deal about us as Americans, and I think says a great deal about what has made us so extraordinarily successful. I am one of those that believes it's appropriate for this committee to inquire into the judicial philosophy of the nominee. Mr. Chairman, your own op-ed piece that appeared in the Washington Post, I thought was not only a very thoughtful work, but one that set forth many of the important questions that we ought to be dealing with. But I also believe for us to request specific answers to potential cases before the court would be a great disservice to the American people. It'd be a disservice because I think all of us would feel how wrong it would be to have a judge sit in judgment of us when he's already made up his mind or pronounced a decision. A willingness to have an objective review of the facts in any case is at the very foundation of the American commitment to justice. I believe we ought to seek a court committed to constitutional principle. Our judges must be guardians of individual rights. Whether they agree with the cause or the issue or not, their job is to stand up and protect our rights, sometimes even for us to make mistakes. I hope also, Judge Thomas, that you and the other judges who sit on the Supreme Court will understand clearly and firmly that amending the Constitution and legislating are not the province of the court, are not now and never should be the province of the court. That these are reserved under our Constitution to others and ultimately to the people that they serve. This committee has approved a number of judicial nominees who I think could fairly be called judicial conservatives. Those approvals have come in recent years as a variety of nominees have come before this court, or come before this committee. I'm very concerned that unlike Justice Souter in some other nominations, that special interest groups in our country have pronounced their decision on your nomination, have come out in opposition to your nomination, even before this committee has had a chance to delve into the facts and the issues before it. This process of sentencing someone before they have a trial, I think, is a bad practice. It's a bad practice for members of this committee. It is a bad practice for interest groups in our society. And frankly, it's a practice that I hope you, Judge Thomas, will never engage in. We must ask ourselves, I think, if Judge Thomas is to be held to a different standard than that of Justice Souter or Justice Kennedy or Justice Scalia or Justice O'Connor. I hope he will not be held to a different standard. I hope the standards that rule the deliberations with regard to those justices will be the same ones that we use with regard to your nomination. In short, this committee should not prejudge Judge Thomas, as unfortunately some have done already. Some discussion has already been laid before the committee with regard to the qualifications and the judgment of the American Bar Association. I believe it's important to have their determination of the qualified status of Judge Thomas in the record, because I think the standard they use in determining that the judge is qualified, I think is so important. Here is that standard, as presented by the American Bar Association. To merit the committee's evaluation of qualified or well qualified for the Supreme Court, the nominee must be in the top of the legal profession, have outstanding legal ability and wide experience, and meet the highest standards of integrity, professional competence, and judicial temperament. A question has already been raised in the opening statements about your commitment to equal justice. In that regard, the American Bar Association has considered that. To quote from the Bar Association themselves, in investigating temperament, the committee considers, among other factors, the prospective nominee's compassion, decisiveness, open-mindedness, sensitivity, courtesy, patience, freedom from bias, and commitment to equal justice. I don't know as anyone's ever accused the American Bar Association of being a spokesman for President Bush. Far from it. But I believe the question of commitment to equal justice has been considered by the American Bar Association. Judge Thomas found qualified. Mr. Chairman, it was 28 years ago that Martin Luther King stood on the steps of the Lincoln Memorial and gave a speech that I believed helped shape the conscience of this nation. He said, "I have a dream that my 4 little children will one day live in a nation where they will not be judged by the color of their skin, but by the content of their character." We're here to learn more about the judicial philosophy of Judge Thomas. But I must say I am flatly and frankly impressed with the personal background and the character of Judge Thomas. He knows what it's like to work for a living. He understands what it's like to truly help others. Throughout his life, he's rolled up his own sleeves to help those in need, whether serving breakfast to disadvantaged children or tutoring school children. Clarence Thomas has been there. He understands our legal system from a wide variety of experiences, and I think that variety of experiences is important in making a justice of the court. He's worked in a legal aid clinic and practiced corporate law, from drafting legislation for the U.S. Senate to hearing cases on the District of Columbia Circuit Court of Appeals. Clarence Thomas brings to the court an understanding of segregation as one who's felt its oppression. He brings to the court an understanding of poverty as one who's experienced it firsthand. And I believe he brings to the court an understanding of the American dream as one who's lived it. Thank you, Mr. Chairman.
Thank you very much. Senator Kohl.
Thank you very much, Mr. Chairman. Judge Thomas, the next few days are going to be important for you, but they will be even more important for the American people. On their behalf, we will be talking with you about basic constitutional principles, which means we will be talking about the values at the core of our country. If you are confirmed, this will be the only such conversation the American people will ever have with you. So we must make an extra effort, Judge Thomas, to get to know you, and you must make an extra effort to help us do that. By design, we give the Supreme Court great independence. Its members are unaccountable to the people, and absent severe dereliction of duty, unrecallable by the Congress. Members of the court sit for life, and they shape the life of this country. We give them this freedom and independence because we expect them to remain above the pull of politics and the flow of fashion. Justice Black put that point clearly when he observed, and I quote, "Under our constitutional system, courts stand against any ill winds that blow as havens of refuge for those who might otherwise suffer because they are weak or helpless or outnumbered, or because they are nonconforming victims of prejudice and public excitement." Judge Thomas, you are 43 years old. If confirmed, You may serve for 30 or 40 years, decades in which you will shape the nature of our country. Before we decide whether to entrust you with this power, we ask you to stand before the public and explain your views, express your hopes, and expound on your approach to the bedrock principles that guide us as a nation. We have an obligation to find out where you would take us before we decide whether we want you to lead us there. So as we begin this process, let me identify 3 of the qualifications which I believe we should look for in a justice. First, we should seek a nominee with exceptional character, and that you clearly have. You grew up in poverty and experienced segregation. Despite that, or perhaps because of it, you went on to Yale Law School. You worked for and earned the support of one of the most distinguished and demanding members of the Senate, John Danforth. You served as head of the Equal Employment Opportunity Commission, and you now sit on a federal court of appeals. So yours indeed is a story we want to tell about America in the 20th century. It testifies to our achievements in creating opportunity for all, from a social contract written for just a few. More than that, it is evidence of your own intelligence, dedication, and commitment. No one can read the story of your life and your success and not be impressed. Nevertheless, as I'm sure you would agree, that alone does not justify your confirmation. Second, we should look for someone who can read the law and relate it to the competing interests of American culture. We want a nominee whose values reflect the diversity of American life, where the Constitution protects all of us, those who live in high-rise condos and those who live in the depths of the tenements, those who work for wages and those who retire on investments, those who call for orthodoxy and those who champion revolution. All of these strains of American life must be protected if we are to keep spinning the fabric of renewal and regeneration which has clothed American history for more than 200 years. Third, we want a nominee with an open mind but a firm sense of direction. When you came before this committee last year, in response to a question I asked, you said, and I quote, that you did not have a fully developed constitutional philosophy. That did not disqualify you for a seat on the Court of Appeals, where you are required to follow precedent. But the Supreme Court sets precedent. It interprets the Constitution in which we as a people place our faith and on which our freedoms as a nation rest. In my judgment, if you cannot articulate a constitutional philosophy, one that includes full safeguards for individuals and minorities, and that also squares with your past statements, then in my judgment you are not qualified to sit on the Supreme Court. I realize that is a strong requirement, Judge Thomas, but it is, I believe, a fair one. So during these hearings, we will want to determine what your philosophy is. We will want to learn what you really believe, and we will want to know how and when and why you came to believe it. Let me give just a few examples of the themes running through your speeches and writings which trouble me. You have openly criticized decisions like Griswold and Roe, which go to the heart of a woman's right of choice. You have been an outspoken admirer of natural law, a doctrine largely dismissed for the past half-century. In fact, you have suggested that, and I quote, it provides the only firm basis for a just, wise, and constitutional decision. You have opposed nearly all forms of affirmative action, and yet, when we met in my office, you told me that you supported affirmative action. And you have frequently expressed disdain for Congress, its members, and the legislative process. Yet your oath as a federal judge requires that you faithfully execute our laws. Your own record raises serious questions. Since you have such low esteem for Congress, how can you expect us to believe that you will defer to congressional intent? And since you have criticized past court decisions about the right to privacy, what credence should we give to your pledge to follow precedent in this area of the law? And since you said that natural law is the only basis for constitutional decisions, why wouldn't you overturn rulings which you believe conflict with natural law principles? I am hopeful that you can resolve these and other questions to our satisfaction. And Judge Thomas, in order for you to do that, you will need to be perfectly candid before this committee. When you came to my office in July, you told me not to believe what I had read about you, that we would see, quote, the real Judge Thomas at the confirmation hearings. This statement suggests that you recognize, as many of us do, that these proceedings are the only way the country and the Congress will be able to assess your qualifications and to determine your fitness to sit on our nation's highest court. You can only help your cause by being forthcoming, so please don't hedge. Please don't give us answers prepared for you by others, and don't hide behind the argument that you cannot prejudge issues. Judge Thomas, we do not have to agree with you on everything, but we do have to be sure that you have firm beliefs and reasoned conclusions about the role of the courts, the Congress, and the Constitution. And we do have to be sure that what you say to this committee today comports with what you have said to others in the past. And we do have to be sure, Judge Thomas, that we know what is in your heart and what is in your mind before we decide upon your nomination. Thank you, Mr. Chairman.
Thank you very much, Senator Kohl. Judge, that concludes the opening statements of the senators. It is now 12:30. As you and I discussed, and I have informed my colleagues on the committee, let me briefly explain what will be the way in which we'll proceed after we break. We will shortly break for 1.5 hours. We'll reconvene at 2 o'clock, at which time the senators who have requested the honor of introducing you to the committee will come to the table at your side one at a time and make their statements of introduction to the committee. When those 6 senators conclude their remarks, I will then ask you to stand and be sworn. After that time, I will then ask you if you would be kind enough to introduce your patient family that's been sitting behind you to my right and your left for the committee to be formally introduced, as is our practice, to your family. And then we'll ask for an opening statement from you. At the conclusion of that, I will begin questioning. We will have each senator, as the senator from South Carolina and I discussed, rather than have this broken up in little tiny pieces, we have concluded that the practice in the past works the best, where each senator will have a 1.5 hour dialogue with you. There is a very important meeting in the Senate today that will take place, as we discussed, you and your staff, or the people with you. We will break every day around as close to 5 o'clock or thereabouts as we can. But there's a very important meeting today in the Senate. One of our members, a very beloved member, Senator Pryor, who was almost fatally stricken with a heart attack, is returned and is in good health, and there's a reception for him, which you're welcome to attend if you'd like. You know so many of us so well. The senator asked what's the time and the place. The time, I believe, is 5 or 5:30. I'm not certain. We'll get the place for everyone to have it. But so it will depend on how far along we are, whether or not I begin, whether one of the members begins his questioning. If it takes us beyond, much beyond 5 o'clock, we will not begin, and we'll conclude before 5. So again, the committee will recess until 2 p.m.
Okay. All right. So it was kind of like filibustering. It's the process, though. All the senators get their however much time, was it 30 minutes, 20, 30 minutes? It seemed like 30 minutes to talk and say their spiel. Accidentally started the wrong place this morning, where we started, I think, the second round. They were talking about natural law, which is the thing that people talk about. You hear some people talk about it when they go to court, and it doesn't really work out in court because it's not something it's not based in the Constitution. The Constitution is and that was Clarence's answer. Natural law is a thing, and it even has its place, I think, in the 13th, 14th, and maybe even 15th Amendments. But the framers of the 13th and 14th Amendments did believe in natural law. That's what Clarence was saying, and it comes up a lot. Other things that come up a lot are abortion and other types of let's see, right to privacy comes up. But that's coming up tomorrow. Today, we just got started. Dropped the new Clarence emoji. I do love these hearings. And after this week, Thomas, it may bleed into next week a little, and we're going to do Scalia as well. I did want to read back something, because I don't get too much analysis. Sometimes I don't really digest this stuff until I'm editing it and I'm watching it for a second or third time. But there was a question about Kamala being on the ballot in places like Wyoming and Nevada that said you can't get on the ballot unless the guy is dead or incompetent, which that's what Nevada says. So in order for Kamala to be on the ballot, according to what I'm reading, in the Nevada, what is NRS, it's like most places have their state laws, Nevada's revised statutes, 293.165 talks about how the only way that she could be replaced on the ballot is under the circumstances of death and mental incompetence. So we will see. The state legislatures may create some sort of loophole for this particular situation. I don't know if it's a calculated move that they're just going to move on without those places. Yeah. Yes, the emojis are growing every day. I enjoy them. I'll be like in bed watching something with Mrs. Dave the lawyer, and then we'll have an idea and I'll jump out of bed and run to the computer that's in the room and start on it before I lose the thought. And with the Hunter one, she's like, go do it now before you forget. Hunter NPC. There you go. Yes. Best emojis in the game. That's what I'm going for. The analysis, emojis, top shelf. So, with that, yeah, we'll call it there. Keep an eye out for tomorrow morning. If you haven't already, please subscribe. Liking helps. I think I did shoot myself in the foot by clipping a hearing. I kind of knew I shouldn't maybe have covered. You all know what it is. The World Health Organization didn't want me to cover it. Let's put it that way. So there's been a little slowdown, but how could I complain? Look, it's just not as it was like really moving quick before that. But yes, all the little things do help. So I really appreciate that. But nothing helps more than just you coming in here and chatting with me, because if it was just me watching these hearings, I don't think I could do it. I do watch hearings by myself occasionally, but this is 10 times more fun. So thank you. Thank you, Brandy. Thank you, Ollie. Thank you, Pumpkin. Thank you, Alex. Who else? Who haven't I mentioned? Jay Humble, you've been here a couple times. Haven't you? Yes, Matt's already gone, so I don't have to say thank you. Yeah, I'll say thank you, Matt, for posterity's sake. So yeah, I'm going to go see, yes, 150. Way to go. Thank you so much. I'm going to call it, but keep an eye out for tomorrow morning. We're going to be doing the next part of this Clarence Thomas confirmation hearing. Thank you so much. Become a member if you want to use the emojis. Like, share, subscribe, all this stuff. Yeah, humor makes it better. That's why I say I like to talk in the chat more than sometimes I miss a few things, but worth it. Matt really is, he gets me going. He's got a direct line to my funny bone. So yes, I will. So Ollie, funny thing is the gifting of memberships is random when you do it. I think I might be able to do it on an individual basis. We'll see. I'll experiment with that with tomorrow. Who's that? I mean, not typically Tate, but okay. Tate wants to come in at the end and drop that one. Are we saying everybody that the left doesn't like is a rapist? They're all like slick little twinks who want to groom kids. Yeah, everybody on the right has raped or will rape as well. Is the left's position, I guess. I'm sorry. It's harsh. It's harsh language. Trying to make it, Oh, working on a duplex tomorrow. Well, just do audio only. Could be fun. Army jokes incoming tomorrow. Heck yeah. You're delusional. Yeah. Okay, Tay. I'm delusional. I can't list on my hands and toes how often that gets thrown around when there's like some really powerful, charismatic leader, especially on the right. Then all of a sudden, that's what gets thrown around. Or Just anything influential. Who was it? It was also dude with the silver hair, WikiLeaks. Yeah, that was him. Take 5 seconds to Google. Oh yeah, because Google's search engine is reliable too, right? Just use Google. Wait, why don't we just go to MSNBC and CNN and take their word for it, Tate? How about you turn off the brainwashing? That's How did I know? How did I know what he watches? How did he know what I watch and listen to? It is hilarious. It's hilarious how racist these people get too. And they're like, Thomas should be kicked off the Supreme Court. He should be what is it? He should be impeached. He flew private. Yeah. Yes. Exactly. Well, Tate, it ain't. That's hilarious. You know where you stand in this chat, at least. With that, everybody, love ya. See you next time. Yeah. Mrs. Dave the lawyer does think that Donald Trump might be a time traveler. That's the conspiracy. Oh. Okay. With that, thank you, everybody. Knowledge is power. Subscribe to more. Be well. Take care. Be safe. I'll see you next time. And, yeah, tomorrow morning, part 2 of the Clarence Thomas confirmation hearings. Possibly Ollie. Come back tomorrow. Love you, Brandy. See ya. Is he even a real? I don't know. I have this conversation with myself all the time, Tate. Am I a real lawyer, really? I don't know. Bye, everybody.